Well, I beg to mention item number 5, my lord. In this case, I need some further time to file my affidavit reply to the affidavit. You have to respond, my lord. Because my lord, the done, my lord.
Okay.
That might have some bearing in the case. So, as an abundant caution, my lord, we had made them party, my lord. Otherwise, we had.
The request is done concept for that. List of 4 weeks.
Diploma, lordship.
Wait, please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 4, lordship. I am for the appellant, lordship. We need some time to file our reply, lordship.
Yeah.
Obliged, lordship.
May I please, Your Lordship? My lord, I beg to mention item number 16 with due consent of the opposite party, my lord. My lord, our affidavit, we require 2 weeks time to file our reply. Very shortly, they have filed their opposition. We want to file our.
Yeah.
I pray for lordship for listing of a pending matter, my lord.
Which pending matter?
My lord, review a petition filed by the Union of India. And
Petition.
it was heard twice, my lord, by the earlier division bench headed by the Honorable Justice Koteshwar Singh. So, my lord, this is a part had remained like that. I submitted an application, but that was not listed. The year 2023, August.
Next week.
My lord, okay.
Lordship, item number 9, my lord, I have taken consent of the opposite party. Well, I may be allowed to withdraw that phone number.
Whether that godown has been constructed or not,
Lordship already constructed.
then what remains?
I may allowed to withdraw, man.
Wants to withdraw. Withdraw.
Obliged.
May I, please, your lordship? The item number 25, lordship. Perhaps my lord justice may not like.
25. Another bench.
Obliged.
May I please, Lordship? Lordship, I beg to mention for a listing of a pending matter. The matter is about the ensure of the passenger in the Silchar Lamding railway section. So, Lordship, this matter is pending since last 3 months, and recently the railway communication has been disrupted because of the landslide. The railway is not taking necessary step to ensure the passenger safety. That is why the intervention of the court is necessary, Lordship.
The railway is not clearing the tracks and all.
Pardon, Lordship?
The railways, they, I think so. The railway is going to clear the track and all.
Yes, they are doing something, but it is not sufficient.
I mean by sufficient.
Since last 10 days, the railway, the train service is disrupted, Lordship.
How many days?
Since last 10 days.
Last 10 days and they're trying.
But
Next week.
Lordship,
week.
next.
Yeah, please, your lordship. I beg to mention item number 11, lordship. Head steps of dusty has to be taken, lordship. I require some more time, lordship.
And concept with the. You are for the.
Appellants, lordship.
Wait for. Granted more time to take further steps. To take fresh steps as directed by this court earlier.
Some obligation.
2 weeks.
Yeah, please, your lordship. I beg to mention for item 22, lordship. Your lord, 22, lordship.
Yeah.
Your lordship may not like to take up this matter. But yes, lordship. I fear. Yes, sir. In the writ petition, my lord.
Another thing.
20.
Yes, sir.
Wait,
Okay.
Well, I beg to mention item number 18, my lord. Here, my lord, petitioner has filed an application under RTA application, my lord. The RTA Act, my lord, but the information had not yet been received, my lord.
You are required to furnish the information that in the year 2015, this assistant had a secondary site
My
for
lord,
the qualification.
That qualification, my lord, now, my lord, they are saying, my lord, HS past candidate also had appointed, my lord. So, my lord, I needed an instruction, my lord. Information whether, my lord,
Qualification was there at that time or not? You have to satisfy that. In the year 2000.
that is why, my lord, petitioner submitted an application under RTA Act, my lord. So as to obtain some instruction, my lord. That information has not yet received, my lord.
Yeah, that you can very well go through the rules and find it out.
My lord, I can understand, my lord, but I needed some information, my lord.
Adjourn. Yes,
Oblige me.
Daily list for orders item 1.
Yeah, please, your lordship.
notice upon the respondent number 3 has not been served till date.
My lord, I have taken steps for
You have taken the steps, but notices are still awaited. You are appearing for the respondent number 3.
I am here for respondent number 1, Lordship. We have already, I am appealed.
And number 4, man. Await return of notices of respondent number 3 for 4 more weeks. Your.
Standing counsel is appealed.
Yes,
Standing counsel.
Item number 2.
Oblige.
so you are supposed to furnish the amended cost title.
This could not be filed. I am filing it on today, lordship.
And the concept of the plan place submitted the amended cost title would be filed during the course of the day. Office to check, place the same. Approve the.
Item number 3.
Please, your lordship. My lord, regarding item number
Respondent
respondent
number
number
10 and 11, you have not
10
taken
and
any
11
steps.
lordship, they already retired lordship, and now where are they are lordship, I have no knowledge lordship, because they are government
Then
officer.
do an application for deletion of their names. If they already retired, you are supposed to furnish the address, and if you don't want to continue them as party respondent, move an application for deletion.
Lordship, that may take some lordship time, lordship, may I pray one thing, lordship?
Yeah.
As already lordship vigilance, as per my complaint, lordship, vigilance already lordship taken the action, but due to filing of this PIL lordship, they have not lordship advanced lordship.
Who has taken the action?
Vigilance lordship, Chief
Then what
Minister's
remains?
vigilance cell lordship.
What prayer you have sought in the petition?
Lordship, this 17 is my prayer, lordship.
So they have already initiated inquiry and they have already conducted an inquiry.
No inquiry yet been taken, lordship, but due to filing of, they are going to taken the action, lordship, but due to pendency of this PIL, lordship.
9, 10, 12, 13, 14, 17, 12, 13. That they have gone to the. So there is the report of the. You can see from this part. Thereafter, there is nothing. So representation to have been. And we come 22nd. When residential right. Then I if there is. 20. This is 21.
So the CM Vigilance Cell has already directed to file an FIR against them.
Yes, Lordship, but that was not taken yet, Lordship. So now, Lordship, may I pray, Lordship, this PIL may be disposed of, Lordship, directing the Lordship vigilance cell to take appropriate action, Lordship, under the law.
That's what their only evidence is on the unboarding. Bring more.
This is the reported that. No steps have been taken for service of notice upon the respondent number 10 and 11. Then the concept of the petitioner that submitted that the respondent number 10 and 7 has now been declared and he is not aware about the present address of the respondent number 10 and 12. It's it's filed by the petitioner raising a grievance that the respondent authorities doing several irregularities in conducting the Mandarega works for the financial year 2018-19, 19-20, and for the financial years 2020, 21, 21 and 22. The 22 under Katigoda Katigoho Development Law of Kachar district is the allegation of the petitioner that the respondents are misappropriating the government funds. Having gone to the contents of the petition, it appears that earlier also the petitioner has filed PIL number 8/21 raising same concern, and this was why the order dated 22nd of February 2021 has disposed of the said PIL with the direction to the principal secretary to take cognizance of the matter, and after hearing the petitioners and the other concerned person take appropriate action. I will person is speaking on. Stop. As per the petitioner's stand, the said direction has not been complied with. Despite the representation is filed on behalf of the petitioners, they move contempt petition in which the principal secretary has submitted a report that inquiry has been conducted. Inquiry was conducted and 6 officials were found involved in the misappropriation funds, against whom appropriate action is being taken in accordance with law. Stop. From the record, it appears that the Chief Minister Vigilance Cell has also issued direction to the deputy. It issued direction for registration of FIR to registration of FIR against the guilty persons. Stop. Having taking note of the above facts, we are of the view that still the grievances of the witness have not been addressed. The grievances of the petitioner has not been redressed. He is free to approach the concern of her for redressal of his grievances. It is expected that if any such representation is filed by petitioner, the concern authority shall take cognizance of the same and initiate appropriate proceedings against the guilty person. With these observations, this petition is disposed of.
Right.
Maybe now. Gone of it.
Item 6,
Your lordship. Was this matter earlier dismissed for default? Thereafter, your lordship on 3/4/2024
Yeah,
These are-
it has been restored.
already restored.
Yes.
Now this case is already step also complete, lordship. So kindly lordship allowed to file affidavit by the respondent, lordship.
We filed
Not file lordship, yet to receive instruction lordship.
any concept of respondent for whom you are representing.
I am for the government was respondent number 1.
What about the others?
Other is health department lordship.
There is
Health.
She is there. She can appear, I suppose. Follow. You can take notice for. Well,
Ms. So-and-so is appearing on behalf of the respondent. So-and-so is directed to accept notices on behalf of the respondent number 2 and 3. Copy of the notification is applied to. The question for the respondent during the course of the day. The respondent may file a response to the notification. Yes. The concept of the respondent, the response to the. Then a period of 4 weeks, list up to 4 weeks. For admission.
Item 8.
My lord, in this case, the respondent should file their affidavit, my lord.
Wait, please, your lordships.
Lord,
Lordship, I'm appearing on behalf of respondent number 32326, lordship. Lordship, humbly pray for some more time to file a reply, lordship.
You are not filed reply till date.
No, lordship.
My lord, government has also not filed a reply, my lord.
Lordship, actually, we are going through very old documents, lordship, hundreds of years old, lordship, and we need some time to go through it. And lordship, there are some materials which needs to be bring on record, lordship. Therefore,
These respondent number, you are appearing for respondent
326, lordship.
326.
Lordship.
What about 7?
7 notices.
Seven is a
has been
newly
included.
affiliated party, and my lord,
Yeah,
father's
they
name has
already
not been shown.
presented.
Petition we have submitted, my lord.
We have submitted. So, this many of the remain in the religious places is still prevalent here in
Yes.
some of the temples.
Yes.
There are some satras, lordship, Vaishnavite satras.
Normally, the numbers in other, but in the specific section, there is a section like they okay, they can go into a there are many different Kirtan. In the Kirtan, where the mostly of Krishna is, we don't forget to use on the way they take so they call it on the basis so certain area therefore being there. So the lady is number 3 section is the section and saying also. So they are remaining the problem.
Service of notice upon the respondent is already completed. Is already effective. Then in concept of getting for so and so, place some time to find comfort to the sufficient time frame for it granted. Start with 6 weeks.
I'm deeply obliged, lordship.
Item 10.
No other. Nobody is very comfortable.
Yes. Fresh step has not been taken.
On respondent number 7, my lord. They have to take steps. In the meantime, I have received the instructions on, from respondent number 5, my lord. I need some time to file an affidavit in the.
What's the matter about?
They have alleged that the work has not been fully.
In the last occasion also, no one was appearing on behalf.
But in fact, my instruction says that the work is complete, my lord, in the
Work is complete.
work of construction of road, my lord. It is complete, my instruction says that. And I'll bring it on record, my lord, by filing an affidavit on behalf of respondent number 5.
I'm appearing from KAC, lordship.
So the extra copies also not been served to us.
To whom we direct, none is appearing on behalf of the.
Let it come next week. Let it come next week. They may come.
None is present on behalf of as per the official report, fresh steps have not been taken by the petitioner as directed by this court earlier. So none is appearing on behalf of the and the petitioner earlier also on
28.
24 none has appeared on behalf of the over in the interest of justice basis petition after a view.
Lodge.
And in the meantime, you bring the report
Lodge.
that the completion of the road is there.
Yes.
Item 12.
May I please, your lordship?
Mr. Bhavi, I cannot take it up. I cannot take it up.
Lordship.
Item 13.
The record is required from the trial court.
Lordship, Rayati case number 66 of 1995, Lordship,
From the,
from the office of the Deputy Commissioner, Kamrup Metro.
who is appearing for the deputy commissioner Kamrup?
Government. Ms. Bora. Bora.
No, hold on, Item 13.
Why this deputy commissioner is not sending the record despite requisition sent by the state? Yeah.
The Deputy Commissioner is not mere party in the.
Whatever it may be, ultimately the government has to inform them that send the record, even though if he is not party. Okay. This court on 29/11/2023 has called for the records of IoT case number 66 of 1995 from the office of Deputy Commissioner Kamrup. The said record has not been received till date. Council appearing for the so-and-so, Mr. R. Bora is directed to ensure that the record requisition by this court from the office of the Deputy Commissioner Kamrup, the
Kamrup Metro.
Kamrup Metro be sent to this court at the earliest. Just after 4 weeks, you get.
Lordship, interim order,
Yes,
interim order passed earlier.
interim order was limited.
Lordship,
The interim order is not necessary because status quo,
status quo.
not
Lordship,
necessary,
because
but they are in
last time-
possession of the land.
Whatever it may be, status quo, we are simply saying. Status quo, the interim order passed by this court shall remain in currency till next stage.
I know.
GA Assam may be, the name of GA Assam be reflected in the court list.
I know.
Item 14.
May it please, Your Lordship. Well, here, I have taken three steps upon the respondent number 8, my lord, and he has received the notice, my lord, as per last office note dated 1/5/2024. Right?
Delay condonation.
Yes, my lord.
How much, how many?
44 days, my lord.
I filed my objections, but I leave it to your lordship.
The matter comes upon the consideration of the IN. To the fair, condone the delay of 44 days in filing the connected appeal. Having, then we consider the respondent that opposed the application. Having heard the learned consent of the parties and going through the contents of the IN number 2 and so, we deem it appropriate to condone the delay of 44 days in filing the connected appeals. Hence, the IA number so and so is allowed the delay of 44 days while filing the connected appeal is condoned. Office is directed to register the connected appeal and list it before this court of 2 weeks.
Oblige, Lordship.
Item 15.
Wait, please, your lordship. Lordship, I am appearing for the respondent number 6, my lord, in this matter. My lord, read appeal and file an affidavit in opposition, my lord. Against that, my lord, we have filed a reply day before yesterday. My lord, may I please to take up the matter next week, my lord. That is not on record, my lord. Affidavit is listed.
Application. Represented to me. Then what you say, then make it. Matter is. Now, absolutely. The earlier instruction would have very careful. We had to confident. There is no finding. Was not in the second box. So the person who answered it, he was already number one. So he just go ahead and put that. Vote. Then the marking everything was noted and he goes by the second. There was a letter to give a report. So he gave a report. Now that is developed in the academy.
Yes. You have already filed counter affidavit.
My lord, affidavit in reply, my lord. Day before yesterday.
Okay, let's consider the. At least, the
Respondent number 6.
respondent number
6,
6.
my lord.
Respondent number 6 has submitted that he has already filed rejoined to the counter affidavit filed on behalf of the appellants. However, the same is not available on record. Office is directed to place the same on record. In this matter. After 2 weeks, interim order it will continue in the next week.
Highly obliged.
Item 17.
This appeal is against the judgment and order dated 14/2/2023. The subject matter of the appeal is provincialization of services under the Provincialization Act. Now, what had happened, my lords, initially.
They just ask you to approach the tribunal.
Yes, I'll just narrate the facts very briefly. What had happened, my lord. Look, during the writ petition, when the writ petition was filed, the private respondent did not even challenge my appointment, my lord. I was just arrayed as a respondent because I was the principal or the headmaster of the school, my lord. There was no prayer against my appointment or my provincialization, my lord. And the challenge was directed to the respondent number 7, my lord, who's the respondent number 7. Now, when the matter came up before the honorable single judge, my lord, the other my lords, submission on facts on merit of the case, my lord, it was submitted that this matter has to go for, because there's an appellate authority and my lords may not exercise the extraordinary jurisdiction and relegate the party who has filed the writ petition to file an appeal. My lords, that was done. But while doing so, my lords, the learned single judge, what the learned single judge has done, my lords, there's no challenge against my appointment. My lord, the learned single judge had in a way a roving and fishing inquiry into the merits of the case and then had set aside my provincialization, my lords. And after setting it aside, then they have relegated it to the,
Where is that?
my lords would come to my lords, page 25, my lords, the paragraph, the second last paragraph from the bottom of the judgment, my lords. The internal page is page number 5, my lords.
Internal page number 5.
5, my lords. The second last paragraph from the bottom.
In the case in hand.
Yes, my lords. I'll read, my lords. May I read?
From the record that.
The scene from records as well as the affidavit of the director of elementary education, Assam, who is the chairman of the state level scrutiny committee, that apparently without verification and relevant records, the services of respondent number 6 and 7 were provincialized merely on the basis of the recommendation of the district scrutiny committee, Jorhat, without considering the fact that there is a requirement of a social science teacher in Nobhanga Jonajati ME school for its provincialization under the 2017 Act, where the petitioner was serving as a social science teacher. The court, after perusal of the relevant documents and records, as well as the affidavit of the DE Assam, found that the state level scrutiny committee did not verify the relevant records pertaining to the subjects sought by the petitioner and respondent number 6, as well as the respondent number 7. It is brought to the notice of the court that respondent number 8, we can skip that paragraph, the next paragraph, my lords. Considering the above, the provincialization of service of the respondent number 6, who's the appellant, my lords, under the provisions of the 2017 Act, as amended, is set aside and quashed. Thereafter, my lords, after referring to a number of judgments, my lord, it was referred to the appellate authority, that both the parties go and approach the appellate authority. Now, it was also submitted, my lords. It would do no good, my lords, if my provincialization is set aside. Because first of all, there was no challenge to my provincialization. Secondly, I'm working in the school, my lords. I'm working in the school, discharging my duties as a teacher, my lords. So let the appellate authority decide, my lords. I only pray for a modification, my lords. My lord may also peruse the prayer, my lords. The prayer is against the respondent number 7. And my lords, it was also submitted, with all due respect, my lord, it was submitted before the honorable single judge that my lord himself had passed orders where parties were relegated under similar circumstances. And even the division bench has also upheld, my lords, that, my lords.
No, then listed for what today?
Notices that.
For admission.
It's an order. It's an order, sorry.
The listed in orders.
My lords, the service with regard to the writ petitioner is complete, my lords. My lord would peruse order dated. In fact, service was effected twice, my lords.
Yes, that's
Done.
something they have also ordered.
Ordered before. In the IA, my lords, service is completed, it is deemed against the private respondent. There was a delay initially.
That is there.
Yeah.
Why it is listed for orders?
That come later. Not being for admission.
You are appearing for
I'm appealing for respondent number 7.
respondent number 7. Who was the writ petitioner?
No, Lordship, I was added as a respondent number 7 in the writ petition, Lordship.
And respondent numbers, the petitioner is included as the.
One, respondent number 1. my lord.
The notice upon him has already been served.
Served, completed, my lords, did not accept. My lords would peruse order dated 12/2/24, passed by my lords. In the IA, my lords, in the IA. There was a delay. In fact, Dusty was affected twice. Once it was received by her brother, and second time there's a police report also that she's not received.
Then applicant has submitted that. The respondent number one by way of filing, writ petition has generated appointment of the respondent number 7 as principal of the concern.
As tutor, my lord.
Tutor Hindi.
Tutor, my lord.
As tutor of the concern school is submitted that though the appellant was implemented as respondent number
Respondent number 6, my lord, in the
the writ petition.
writ petition.
Respondent number 6 in the writ petition, but his appointment as
Tutor, my lord.
tutor in the concerned school was not under Chennai. Despite that, the learned single judge has set aside the appointment provincialization of the respondent of the appellant. Appellant. Issue of the service of notice has already been affected in the parties. However, on the parties, taking into consideration the circumstances, we deem it appropriate to order that the order passed by, we deem it appropriate to direct that the order passed by the single judge of setting aside the provincialization of the appellant while impugned judgment is stayed over the however, the chairman state level scrutiny committee to whom the respondent number 1 has filed an representation may continue with the proceedings. They have filed that application before.
I have not filed, I have challenged, my lord, directly.
No.
The respond, they must have filed, my lord,
Must have filed.
because they have to file to get the appointment. I'm not sure, my lord, so I'm not.
Do you have any information? No. However, the respondent, the chairman, state level scrutiny committee is free to proceed with the representation, if any, filed by the respondent number 1 as the respondent number the number 1 pursuant to the liberty granted by the learned single judge.
I'm very grateful, my lord. My termination has been set aside, my lord.
State.
It's state. I'm very grateful, my lord. I'm deeply obliged, my lord. Deeply obliged.
Item 19.
Will await the service of notice upon.
appears for
I have been instructed to appear, my lord, before your
On
lord.
behalf of
On behalf of sole respondent, man.
sole respondent.
Why?
Yeah. As per the office report, notice upon the sole respondent will not be. As per the office report, notice upon the sole respondent has not been served. However, Mr. So and so put an appearance on behalf of the sole respondent, service is therefore complete. Yes. What do you want?
Service completed, my lord, that
This
is
for admission after 3 weeks.
Item 20.
Sir, everything, no? Service evidence. Well, we have taken steps in the IA.
Settled.
Dim Muslim. Okay. 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 ठीक है बोलो नेक्स्ट तो
But while doing this, data entry for the people, but while doing it, it's really applicable to procedural design. It is not everything being digital. Which is good. Other systems that are statement of some people they take they follow it, possible and then they so that is where it goes. Always be taken care of. I think of it.
fresh level fresh level
Notice upon the respondent has not been served.
But we have taken steps, but the office note reveals that it is served, but nobody has appeared.
No, office note had not said.
4-5 notice.
4/5/2024 office note said neither AD card received nor
But,
notice
we-
note has been
but we may
received
be-
by the concerned section to date.
No, sorry, no, we may be allowed to take a fresh one in the appeal moment.
Then the notices were issued.
No, sir, it's only issued on 2-5. 2-5.
But in the appeal on behalf of respondent number 1, we will take fresh steps.
2-5. 2-5. This is to our 2-5/24.
The await return of notice of respondent number 1 for 3 more weeks.
Lot. No problem.
For admission, item 21.
May please, your lordship. In this matter, I pray for some accommodation. Mr. Air Bhuya will appear. He is on lag, my lord. If possible, after some time, my lord. Mr. Air Bhuya will appear, my lord, after some time.
Because nothing to, they have not been able to remove that.
But then
Item 23.
May I please, lordship. Lord, I have received a periodic document in this case, my lord. Short time may kindly be given to file the affidavit. 23.
what happened in this, before the land is single there?
The matter is fixed on 15th of May.
15th of May.
The district collector has filed a PG, but excise department has not filed it. Even the appellant also not filed it.
Do one thing, we'll dispose of this writ appeal by making this interim order execute passed by us.
That can be done.
And ultimately it has to be decided by the learned.
Learned single.
Absolutely. This. By the appellant being agreed with the author dated 15/3/2024. Whereby the learned single judge by issuing notices to the while entertaining the writ petition number 1516 of the 2024. Directed the state respondents not to issue license to the appellant pursuant to the NIB dated 14/11/2023 till the next returnable date. While entertaining the present writ appeal, this court has stayed the effect and operation of the order dated 15/3/2024 passed by the Ranit Singhal Judge, while taking note of the fact that before passing of the interim order dated 15/3/2024, license was already granted in favor of the appellant. Stop. Since the matter regarding allotment of liquor shop in favor of the appellant is pending consideration before the Ranit Singhal Judge in the writ petition number 116, we deem it appropriate to dispose of this writ appeal while observing that, while directing that the respondent state may allow the petitioner to operate the liquor shop in question till the final decision in the writ petition number 156/2024 is made clear that the question regarding the allotment of liquor shop to the appellant will remain subject to the final decision passed by the single judge in the above recorded petition. With these observations, this writ appeal is disposed of.
In the meantime, appellants and file affidavit, my lord. The state respondent also
Pleadings,
file.
pleadings obviously will have to be exchanged. Just one perhaps, my lord, the correction is perhaps required. Your lordship, I heard your lordship saying writ petitioner. It should be writ appellant, if I'm not mistaken. Deeply obliged.
Item 24.
That order.
Yes, I have the order.
Concept of the appellant is submitted.
They appear, my lord.
May I please your lordships, appeal memo not
Yes,
been served.
I'll-
upon the
I'll-
lordships. The matter may be taken up any other day, lordship, no copy with me.
Several appeals involving illegal issue has already been admitted by this court. Full stop. Admit the copy of the writ petition be supplied, writ appeal be supplied to the counsel for the respondent
I have served.
during the course of the day.
Yes, my lord, I have served.
This appeal along with writ appeal number 50 of 2020.
Lordship. Obliged.
Item 26.
Not by.
May it please your lordship. Lord, this appeal is.
Yes.
My lord, this appeal is listed for admission of hearing, my lord. My lord, the impugn order is a common order. There consist so many writ petitions, out of which.
Brother, Mayor is not able to hear this matter.
I cannot take up.
This before another bank, of which, not.
But copy of the detail may be served to us. It has not been served. Only the.
Since we are not thinking of the matter, how can we pass any orders?
My lord, I am not getting, my lord, I am not properly hearing. My lord.
Brother Umni is not interested in hearing this matter since he appeared in the matter
My lord,
before the learned single judge.
my lord, could it be any early date, my lord?
We simply made an exception. You please ask the registry to give appropriate date.
I am grateful, my lord. I am grateful.
Item 27.
My lord, here in this case.
Copy दिया ना ना additional activity तो हम ऐसा नहीं Yes.
My lord, other day lordship has asked me to show decision of the Supreme Court.
Yes.
Showing the judicial authority of the High Court to amend the law, challenge the legality of the validity of this.
Not the challenge the legality. In fact, your prayer is to issue a direction for amending an act or to prayer part.
My lord. Here, my lord, we have
Page 66.
given two decision, my lord.
Just the
One is reported as 2022 11 SEC
Just a-
455. My lord. In the reported judgment, my lord, in para 2, it's quoted.
amend the foreigners tribunal order 1964 inserting appropriate initial onus. This is what your prayer.
My lord.
And second is ensuring the fairness of reasonability and to issue amendments of the direction. Foreigners tribunal order inserting appropriate provisions so and so. And to issue a writ of amend the Foreigners Act 1946, inserting provisions of methodology, mechanism, and identification and determination of statute of suspected person.
Well,
Now, this is what your prayer is. The Supreme Court has said the court can issue direction in this regard.
my lord.
While exercising powers under Article 226, this court can issue direction that amend this law in this fashion.
My lord, when the Supreme High Court can, when challenge can be made, validity of the law,
Certainly,
why not, my lord, amendment, my lord?
Validity is not, can't be.
My lord.
This is not the function of the court to legislate. Function of the court is to review the any law or have a judicial review of the law.
My lord.
That is not.
Yes, my lord. My lord, there's no difference, my lord.
So
No
great
difference at all, my lord. My lord, when, my lord, the validity of the law can be challenged, why not, my lord,
Show us
the
any law.
amendment, my lord?
Well, show us any law simply by logic. You can't say, sir, show us any law. Yes, that the High Court is empowered while exercising powers under Article 226 to issue a direction to the legislature to amend a particular law in particular fashion. Show us the law.
My lord, I have given you citation, my lord, that
These
relates to,
citations, yes, what is,
My lord.
these are the, first of all, these are under Article 32
my lord.
and not under Article 226. And what it says shows that what the Supreme Court has held that yes, the High Court can issue a direction for amending a particular law in particular fashion. Where is which para you
My
are
lord,
referring to?
my lord, in the other case, my lord, writ petition civil 1-2-0020. In this case, my lord, the Supreme
The
Court says that
petitioner in
it
person
can
will
be,
get-
my lord.
okay.
Judicial reviews can be by the High Court, my lord. Judicial review, my lord, include that also, my lord. Everything, my lord.
Judicial review is altogether different. We are admitting.
My lord,
yes,
when
we
my
have
lord,
a judicial
amendment,
review.
my lord, when there is,
We have a power of judicial review to go through a law, whether it is unconstitutional or not. But certainly we can't have power while exercising this power under Article 226 to direct the legislature to enact a law or to amend a particular law. It can't be the power. This judgment is neither here nor there.
my lord, I may be given some more time to.
Even when we have taken care of this, not part. But what is happening, the difference between the state. The foreigners, right? Is affected to be a foreigner. And the police here that power under the if you just drive on the police function is done by the prime minister. Because if Muslim model is violated, they'll come up with a function, not given case.
Let me concept of the petitioner please some more time to satisfy this court regarding the query raised by regarding the query raised on 26/2/2024. Just after 8 weeks.
Leave lovely.
There is a period. Once then.
Item 28.
Before also, I said, yeah, okay, I'm agreeing consent. When we realize.
So this is the appeal by the revenue, where question of law is whether the department is liable to pay interest in the exemption notice. And last occasion notice was issued.
Final order passed by the state bank. On last occasion also, it was listed then. This can't be a question of law, sir.
Lordship, this type of appeals were decided by the Honorable Court. I have submitted one order passed by the Honorable Court in Central Excise Appeal 7 of 2022. But the issue has already been decided by the Honorable Court, and we prefer the SLP. Similar order may be possible.
The concept of that. Yes.
Actually, Lordship, I don't have instruction. Lordship, Mr. R.S. Mr. He has some personal difficulties. So, Lordship,
We are dismissing this appeal.
Yes, Lordship.
Okay. Then concept of the appellant has frankly, has fairly submitted that the issue involved in the present appeal is squarely covered by the decision of this court rendered in 14/8, rendered in Central Excise Application number 7/22. Dated 14/8/2023. Whereby this court has dismissed the appeal filed on behalf of the revenue with the direction that the interest on delayed payment of refund shall be paid to the SSC within a period of 2 months. Within a period of 2 months.
Subject to Lordship undertaking given by them. Lordship
Subject to subject to the condition that the SSC shall furnish undertaking that in case the revenue succeeds in SLP of Messrs. Dharampal Satyapal Limited, the interest amount shall be reimbursed to the department. So in view of the above, this petition, this appeal is disposed of in terms of order dated 14/8/2023, passed in exercise application 7/23.
Much obliged.
Item 29.
May it please your lordship. Lord, exactly on the same issue, a coordinate single judge, my lord, at page 48, had taken a contrary view, and that was earlier in point of time. If your lordships would kindly come to page 49, my lord. Second subpara. Sri so learned, has a lordship got it, my lord. Page 49. Sri so learned senior counsel for the petitioner submits that as long as the authorities proceed in accordance with law and by following the principles of natural justice, he would not have any objection in the matter. Similar is the counsel for the petitioners in other writ petitions. It is no doubt correct that in a case of contractual engagement, the terms and conditions of contract would govern by the service condition of the employee. In the present case, the contract agreement signed by the petitioner does not have a clause permitting termination of contract at any point of time if services rendered by the contractual staff was not found to be satisfactory. However, it is to be noted herein that bare perusal of the impugned order of termination demonstrates on the face of the record that the same was issued on the basis of finding of inquiry proceeding conducted behind the back of the petitioner, wherein it has been projected that the petitioner was guilty of misconduct. Therefore, the order of termination of service of the petitioner dated so is not only based on allegation of misconduct, the same is also stigmatic on the face of the record. In other words, the impugned order of termination dated so was founded on allegation of misconduct. However, petitioner was not given any opportunity of being heard in the matter. Therefore, it's a clear case where the respondents have acted in violation of the principles of natural justice. So accordingly, my lord.
Where is the termination order?
Yes. Termination order is at my lord 44, my lord. Whereas it has been reported by CEO Dhimaji Jila Parishad, by later dated so that Sri Jan Saikia, computer assistant of so under Bordoloni Development Block, has been arrested on 17/3/23 in connection with CIDPS case number so, added the section so and was in police custody for 4 days. The arrest and subsequent police custody of the employee has become embarrassing to the employer. In view of the above, in provisions of clause 9 of the contract, Sri Jan Saikia under Borderline Development Block is hereby terminated with immediate effect. In lieu of notice and in view of the circumstances, 1 month salary is to be paid to the concerned employee.
This clause 9.
Clause 9.
Yes. And the page 31 is the CA, my lord, and clause 9 is at page 32.
Termination clause.
The contractual staff undertakes not to disclose, divulge, or make public, except on legal obligation, any information that she may acquire in course of his work without written consent of the agency. So clause 9 is not even attracted. 11, termination of contract. The agency reserves the right to terminate the contractual agreement at any point of time if it is found that the services rendered by the contractual staff is not satisfactory, or if it is found that any declaration of information furnished by him or her proves to be false or willfully suppressed, or if there is any breach of any of the terms and conditions of this contractual engagement, or if the contractual staff is found to be involved in any act of indiscipline or misconduct, or if the contractual staff is found to be involved in any act that may become embarrassing for the agency
or if the contractual staff is absent from the.
Yes.
My lord, I have read the judgment rendered by a coordinate single judge, and the impugned judgment is at page 54, my lord. 54.
Yes.
Para 8.
Yes.
Hence, it is submitted that as the conduct of the petitioner was found to be involved in an act which has become embarrassment for the respondent authorities, it was within the power of respondent number 2 to terminate the service of the petitioner. The court finds that in terms of the contractual employment of the petitioner as computer assistant, clause 2 of the said term provides that contract may also be terminated without assigning any reason thereof before contract period by other party, subject to giving 1 month's advance notice to the other party. Moreover, as indicated in clause 11 of the agreement, in view of the arrest of the petitioner in connection with CID case number so-and-so, it cannot be said that the conduct of the petitioner could not have been found to be embarrassing by the respondent authority. As the service of the petitioner is terminable by giving 1 month's notice, the court finds that petitioner is disentitled to the relief of his contractual service being restored in view of provisions of section 14D of the Specific Relief Act, which provides inter alia that a contract which is in the nature determinable are contracts which are not specifically enforceable. Therefore, the court is of the considered opinion that under the facts and circumstances of the case, the petitioner is not entitled to any relief. My lord, when we talk of service, my lord, we are on a different jurisprudence, my lord. And this dictate of a dicta of Specific Relief Act, whether per se would apply, that's a question to be gone into. Now the matter is, my lord, where are the charges proved? I haven't only been arrested on some mere apprehension.
What it may be,
My lord.
ultimately the charges are of leakage of question paper.
No, that was nothing to do with this case. Yes, charges pertains to, my lord, leakage of question paper of metric, HSLC examination. Now, my humble submission is very simple, my lord. There are certain allegations, which allegations or rather determination is founded on some misconduct. If that is the provision, premise, then I'm entitled to at
Not
least.
embarrassing for a agency that his employee is involved in some criminal case and was arrested for that. Is it not embarrassing for the employee agencies? And particularly the nature of case, whatever it may be rightly or wrongly. Ultimately, it's a contractual appointment. It's not a.
No, my lord, the fact that we have been given contractual appointment, lordship will kindly appreciate we do not have any bargaining power. Now, my lord, no, lordship will have to see, end of the day, we are serving the state. Going by the nomenclature of the appointment, lordship, my rights cannot be determined.
Yes.
Here is a case, based on some allegation, my lord, I am sought to be removed. Am I not entitled to some inquiry?
Allegation. They have not even alleged. They have simply said, since you were arrested and it is embarrassing for the agency in a criminal case.
Well, I was arrested on suspicion. I was not arrested.
That's right. Even though suspicion, even the charges are framed and even you are, ultimately you are acquitted.
No, my lord.
Then also it is.
No, apparently there was some, no, well, I'm not saying that there should be a regular disciplinary proceeding. That I'm not even saying that.
Can't be.
Am I not entitled to a notice, my lord, where I'll be put to at least my perspective in the matter?
Is it a fact that you were arrested?
Yes, I was arrested.
That's enough.
If that is the position, my lord, then so many government servants are arrested, they are not terminated from service.
That is their permanent, they are
that is the
permanent in
point.
that. They are permanent in that nature and their services are governed by the service rules as well as Article 311 is also there.
No, my lord, Article 311 may not be applicable, but principles analogous to Article 311 to have to be applicable.
It is a fact that you were arrested and the employer feels that it is embarrassing for them. That's it. That's why only they have inserted the clause in the terms of contract.
Oh, my lord, those clauses are tailor-made, my lord. What control do I have over those clauses? My lord, recently there is a judgment from the Honorable Supreme Court. Can I just place this on the
Yes.
My lord, recently there is a judgment by Honorable Supreme Court on a particular point regarding on interpretation of Uma Devi, my lord, where Honorable Supreme Court has taken note of this nature of employment aspect. The recent judgment, my lord. No, my lord, my humble submission is.
To be very frank, the persons indulged in this leakage of question paper, this is crime against the society, and ultimately we are inclined not inclined.
No, my lord, that's the
Whatever it may be, even though
suspicion.
allegation- Suspicion, that's right. But this question paper leakage and this irregularities or some fraud in appointments, these persons don't get any sympathy.
My lord, my humble submission is, lordships will give me some time, I'll have to play some case law. So because a single judge, there's a two decisions. One single judge has held one way.
Sir, the single judge has said, since they have conducted the inquiry and removed him on the basis of misconduct, they are required to give him a notice.
This is also misconduct, my lord.
Not a misconduct. They have not even mentioned in the order, sir. They have simply said you are arrested, therefore we are, the employee is embarrassed, and therefore we are not going to continue. That's all.
No, why I'm saying so, my lord, on this point, several cases are pending. Eventually, my lord, fate of this case will decide so many cases. But you will give me little opportunity, I would like to place few case law.
The persons having this involved in or suspicious in this paper leakage cases. Not at all.
My lord, people having some relevance is ruling this country, my lord. We are talking of my lord.
So that is, for that we are to blame. We have to blame for that.
No, my lord.
Ultimately, the citizens of the country have to
lordship,
blame because we are electing them.
No, lordship will
Despite
kindly
knowing
appreciate
all
one.
this, that they are indulged in so many things.
No,
that is
my humble submission is,
that is the-
since this case is going to determine the fate of so many cases, lordship will kindly give me an opportunity. I would like to praise. And now I have got the judgment, my lord. My lord, I'm just reading that paragraph 5. This is, my lord, 2024 Supreme Court, that is SC 374. This is Union of India, Binod Kumar versus Union of India. I'll hand over the copy, my lord. Having heard the arguments of both sides, this court believes that essence of employment and the rights thereof cannot be merely determined by the initial terms of the appointment, when the actual course of employment has evolved significantly over the period of time. So what is contained in my initial order of appointment and the terms, that is not decisive. That's the recent view, my lord. The continuous service of the appellant in course of continuous employment in the capacities of regular employee performing duties indistinguishable from those in permanent post, and the selection process that mirrors that of a regular recruitment constitute a substantive departure from temporary and scheme-specific nature of their initial engagement. So, my lord, therefore, law has developed. What I'm saying is, Lordship will give me little opportunity, my lord. I would like to make some argument on this. As I've already submitted this.
Because this is the agreement of the event of the
এখন এগ্রিমেন্ট করা নাই নাকি বললো And my lord, the respondent will also produce the agreement based on which they are acting.
First of all, you please satisfy only, then will.
No, I was thinking lordship will give me little time, so I made this submission.
But
Next Monday, my lord. My lord, sorry, could it be on Wednesday, my lord? Monday, I'm told I'll be not there. Monday, Wednesday, my lord.
Item 30.
Citation to the. Citation.
But in this case, respondent number one was supposed to bring some records.
Yes, my lord, we were supposed to file an affidavit. The documents have come bulk, my lord. We wanted the assistance of a staff of the department, my lord. Right now, they are slightly unable to assist us. Lordship will give us some time and we'll file the affidavit. Otherwise, affidavit we have prepared.
They have extended the protection. The 10 to 5 community. And they are not trying to say what were the preceding factors there to include them. Otherwise, the power to include them is there. And nobody can be, it's a government thing.
Item number one.
Because this is a protection, this is a beneficial protection to protect those individuals.
When conscious of the respondent number one, please some more time to file counter to the petition. Time to report is granted, list up 6 weeks.
But let it be 4 weeks only.
4 weeks.
Item 31.
My lord, here government affidavit is also filed, affidavit, my lord, 2 page affidavit, my lord. Pleadings are ready, my lord. Can we fix the hearing, my lord, on 16th, my lord? On 16th of this month. It can be
So
disposed of.
how the state is encroaching over the functions of the autonomous
Yes, my
council?
lord, yes, because under the 62,
Some
the lordship knows, my lord,
are there.
the lordship kindly see, in case of any central scheme also,
Yes,
yes. The lordship kindly see annexure E, page 73,
annexure E page.
73. 62.
Yeah,
My lord, the PWD is a elected subject, and is an elected subject to the autonomous council. The government of Assam cannot take up any scheme under the roads, even if it is PMJSY road, my lord, sponsored by the government of India. Then also, as per clause M of the 1995-96 memorandum, the implementing agency is the autonomous council, not the state government, or not even central government. And secondly, my lord, annexure A, page 75. The secondary education, elementary education, these are allotted subject, my lord, to the council.
Go back. In terms of, it will be going back to Karbi Angalam, depending engineer, they are working. Under them, the work will be done.
ultimately the work is to be supervised by whom?
My lord, it is the district council, my autonomous council, my lord, as per clause M of the memorandum of understanding. This is a long checkered history.
If the superintending engineer of the autonomous council is going to supervise the work, how you are affected then?
No, we are on my lord 6th schedule, the power allotted to us. Even central government agencies, the fund is allotted by the central government, then also, my lord, as per the memorandum of understanding that was reached between the parties, there was some turmoil, my lord, of insurgency. Ultimately,
Concept of the appellant, petitioner has submitted the pleadings are complete. इतने लिख दीजिए. Pleadings are complete. By this writ petition, the petitioner has raised the grievance that the state government and its agencies are gradually encroaching upon the functions of the autonomous councils in two districts. Full stop. The said allegation is denied by the respondents. Full stop.
Yeah, my lord, there are other things which are there to comply with.
Having heard the land council of the parties, we are of the view that matter requires consideration. Hence, admit no need to issue notice as parties are already represented. This matter in due course.
My lord, my lord, it is closed.
Yes, we have already admitted the matter and listed for hearing.
Yes.
Item 22.
Lord, this fencing matter relates with the Golpa Municipal Board. My lord, lordship. Series of matter, lordship, I would like to take up this matter. Golpa Municipal Board.
Series of matters, if by one authority, then that doesn't mean.
I just, my lord, I informed you, lord.
So what's wrong in that?
But the thing is that, my lord, I have.
They are not having any funds.
Lordship, we also recommend, lordship, kindly see that we are not disturbing. Lordship, he is, my lord, now 68 years old person, my lord. Suppose if he get 25,000 quarterly, my lord, I think within his life he cannot receive this entire amount, my lord.
Ultimately, what is the other way? You
Other,
suggest
my lord, there are two release basically, my lord, that current pension has been allowed, my lord. This honorable court now is receiving. They have problem. Only lordship may otherwise dispose of this matter. The 25,000 quantum, if lordship may little bit, my lord, give a relief to the my lord. This otherwise he is also a very sick person. He started medical treatment. My lord.
That's right, but ultimately, if the municipal board is having sufficient funds,
Quite right, my lord.
And one more thing also has to be decided by your lordship. Section 53 of the Assam Municipal Act, lordship, where it is stated either gratuity or pension. So here in this case, lordship, from the documents that will have been supplied from the Goalpara Municipal Board, it is in the both has been given, lordship. So it requires a hearing, lordship has to look into
but
this matter.
ultimately, you are aggrieved by this 25,000.
No, we are paying, lordship, as per honorable court has decided. We are paying.
What is to be decided in this?
Lordship, this is the gratuity and the pension. Both has been given. Whereas as per the Municipal Act, lordship, this is either gratuity or the pension, lordship. So this point has to be
My lord, this
decided,
issue has already been dealt with by this honorable court. They never opposed. My lord,
no, lordship.
You never opposed that. In fact, your counsel has offered that they are ready to pay.
There is judicial order, my lord.
Installment till the final payment of the is dues. You have admitted here.
Lordship, we are paying, lordship, as has been.
You are paying them then.
Yes, lordship. But this particular issue, lordship.
He is agreeing.
Yes.
The appellant is agreeing that this amount of rupees 25,000 is less and therefore it will be enhanced.
Yes.
So enhance
So as per lordship's direction, we are paying. Current pension has been issued, lordship.
25,000 you are paying quarterly. Enhance it.
No, lordship, we are paying the regular pension. Yes, lordship.
My lord, there are two parts. One is outstanding dues. One is outstanding dues where the learned single has decided that the quantum will be in my lord proportionate. Second thing is about current my lord that pension amount. This honorable court, my lord, division bench is directed to pay him a regular my lord that pension amount. Now he is receiving on a monthly my lord.
And in addition to that, rupees 25,000 quarter.
That outstanding amount, my lord.
If you are getting pension regularly each month, and in addition to that, if the learned single this is ordered that due amount be paid in the installments, what's wrong?
Earlier it was not there, my lord. This honorable court affirmed about that my lord current pension amount. This honorable court, my lord. Therefore, my lord, only 25,000 lordship can receive that. If we my lord,
How much pension you are getting? Monthly pension you are getting?
My lord, nearby 18,000 something, my lord.
18,000 at least now.
But 25,000 quarterly, my lord. Don't
yes,
lordship, can it be 50, my lord? Lordship, don't mind, my lord.
Can it be?
50,000, my lord, quarterly, my lord. Just double, my lord. 1 lakh was there per month.
Why not the 1,20,000? The fact facts of the case, the order is not private domain. Okay. Taking note of the fact that municipal board will the amount of increase would like what appellant, the nothing that directed the municipal board to pay the appellant rupees 25,000 every quarter. The same should be paid by the last week of third month, and the quarter will be counted from 1st January 2022. Taking note of the in addition to the amount of 25,000 quarterly, the appellant is getting
monthly 20.
getting monthly pension regularly. We don't find any case for interference, hence this rate of being disposed of.
The direction may kindly be given, other may become more difficult.
One direction.
Only that may be continue, my lord. Other again, my lord, the problem.
Leave us to say that
Only one line, my
the
lord.
municipal board will continue to pay
My lord.
rupees 25,000 per quarter to the petitioner as directed by this court till the whole views are clear.
And my lord, current pension may be pension. My lord,
There is
only
the
one
going
line.
on.
My lord, very difficult, very difficult. Lordship, he is old person. Only one line, my
come
lord,
again.
that current pension may also be continued. Otherwise, they will again disturb, my lord.
Why they will disturb?
My lord, it is very
We are not
difficult.
passing any order in this effect, sir.
My lord, earlier this honorable court passed a direction to pay the current dues, my lord. Current monthly, my lord.
It is
That is there, my lord.
lordship, what he is saying,
It is there,
lordship.
my lord.
That is their undertaking and not direction of the court.
My lord, they order, my lord, this honorable court to pay the current, my lord, monthly payment, my lord. He is receiving, my lord.
Entitlement shall be paid to the appellant.
That is the assurance given by them.
Yes, lordship, and we are paying it as per his lordship.
There is,
What else he wants,
What
lordship?
else,
Mr. Jamaria, please.
My lord,
Now you are
about my,
asking for
my lord,
something which is not at all, why you are apprehending that?
my lord, monthly pension, only one line, my lord, it will help the all men, my lord.
No, you are already getting, then where is the question of,
If suppose this dispose, my lord, if there is no single line return, they will not pay, my lord. They will again stop.
we'll see to it, then come again. File a review petition, we'll do it.
But otherwise, one line, my lord, will help us.
Lordship, I have objection to that, lordship.
My, she has every objection, my lord.
Yes, next.
Item 33 and 34.
Your lordship may kindly peruse the order dated 26 to 24. Your lordship.
24. Civil provision, yeah.
My lord, 2018 rules, we have made the provision where we had said that 5% of the vacancies will be for direct recruitment from grade 4 to grade 3. Lordship had noted that 2003 rules. In 18 rules, there is a provision for direct recruitment reserving a certain number of posts from grade 4 to grade 3. The word promotion was not used. That is what we are trying to rectify now. Given the events which took place a little time ago, we have not been able to do it till now and need some more time, my lord. It is before the department. They need to bring in that word promotion into the rules.
So you are
The word promotion has to come in.
insert that word?
My lord, yes.
You are willing to insert that word?
But that is what the department is.
Last occasion that
file
was
is being processed
submitted.
to insert the word. It is not that we are not.
Okay, Mr. Armand, is standing on for the education department. Has submitted that the state government has principally decided to insert the word promotion in the rules of 2018. However, on account of
Because we had done it by notification, which was set aside by the learned single judge, that the rules
That
have
we
been
have
notified
changed.
by an OM, so you do it directly in the rules. We tried to do it, but it was by an OM, so now we need to get the rules amended in the proper manner. That is what we are trying to do.
If there's some, if there's 3 months time to do the needful.
3 weeks.
3 weeks time to do the needful. Just after 3 weeks.
Item 35.
Here, your lordships, I am, before my friend starts, your lordship. Here, your lordship, before my friend starts, your lordship, I am appearing for respondent number 6, your lordship. I am preparing a small affidavit in this particular case, your lordship. Some additional material he has placed, your lordship, in the appeal, your lordship. I may be giving your lordship 1 week time, your lordship. It is already ready. The deponent will come and respondent number 6 will come and within.
We can consider waiting for the respondent number 6, raise a week's time to file counter to the
lordship, to the
writ appeal.
Lord.
Time period for is granted just after 10 days.
Always.
Item 36 and 37.
Wait, Mr. Lordship. In this matter, Lordship, last time Lordship directed respondents to file their affidavits. So they have not yet filed it. That we record because petition stage also no affidavit was filed.
I mean, possibly, I do not know. I was not there on the last occasion because I appeared before the almost single judge. Affidavits are not required in a writ appeal matter.
There is no requirement.
No, there is no
No,
requirement.
Lordship, the petition stage also affidavit is not filed.
I'll
Up
argue.
to them.
I'll argue.
Not filing, then
Rest-
We produce records before the almost single judge. Almost single judge has examined the records and thereafter passed the order. There are specific findings on that.
We had no opportunity to examine, see the records, Lordship, that was produced.
Consultant, the single judge has taken into consideration all the records and found that you have already relinquished your
That is there we dispute. Let them file an affidavit. Why they're filing, filing with them?
Why you are disputing? You are simply saying these are the 4 signatures.
Yes, Lordship, because we did not even know. We are the landowners, we are cultivators in the
Neither
land.
here nor there, sir.
Lordship,
It is neither here nor there. What is the proof that these are the 4 signatures or nothing else, only a vague allegation?
Lordship, our cultivable land, my livelihood have been taken away by the government without our knowledge.
It may be since the learned single judge relied on that, you have relinquished your interest in the.
We have not
properties.
relinquished, that is, we have never relinquished it.
The documents are there.
We have not seen those documents, it is relying upon it, Lordship.
The learned single judge has seen those documents, sir.
Our, Lordship, livelihood has been taken away, our properties have been taken away, land has been taken away, Lordship.
If a person
And
knowingly
without following
relinquished
the-
his share in favor of the state government, what the state government would do?
This is our, Lordship, that our constitutional right of our lands, that is, at least they should have proceeded under Land Acquisition Act or the.
File to release it. What is it? These are not limited. They It has become the petitioner's burden to establish the application for public. That was the same would determine declaration history, including answer about oral and evidence examination from the full-fledged trial.
Yes.
Lordship. Lordship feels that this can be heard without affidavit, then it may be heard, Lordship, someday maybe he fixed.
They are not willing to file an affidavit, we can't force them.
Okay,
Decide
then-
it without
then
there
Lordship
being
may-
any affidavit filed by them.
Understood, Lordship, understood. If they don't want to file affidavit, all right, it's there better. Lordship, then in that case, get me fixed for final hearing, Lordship, because my counsel
We
will
are here
engage
for
me.
final hearing, sir.
Lord, counsel will engage me also not there.
Not the argument.
Some other day, Lordship, so that my counsel will engage me, so not today, Lordship, any other day next week, Lordship, no problem. We'll argue the matter.
On the concept for the appellant has submitted that counter affidavit has not been filed on behalf of the respondents. However, the counsel for the respondents are has submitted that in the fact that they are not willing to file any counter affidavit.
It's not necessary.
To the writ appeal.
I say it is not necessary.
Not necessary to file any counter affidavit to the writ appeal. So this appeal after a week, that they will at this admission stage will consider it, whether it requires admission or to be disclosed. Yes.
Obliged.
Deep view.
Item 38.
Yeah, the pollution.
May I please, yes, sir. Lordship, Lordship, in this matter, pleadings are complete. This matter may be come up for hearing. Your
The pollution control board, the emissions are within the limits of the structure. This is not within a residential area.
But the basic case of the petitioner is that it has been set up in a residential area. That is not correct, my lord. It's in an industrial belts, na? Industrial area. And my lord, we are all following the norms. We set up the industry after obtaining permission from the
Pollution Control Board has also verified it.
Yes.
What
Yes,
sir.
Your
What
Lordship,
are your apprehensions? They have been addressed here.
Your Lordship, in this matter, my learned senior colleague will appear. So,
Yeah.
Item 29.
deep view.
May please, your lordship. My lord, here in this case, my lord, respondent number 10 has filed affidavit in opposition. We have filed a reply to the affidavit today, my lord. And in that affidavit, my lord, we have covered some new development, my lord.
No.
My lord, the State Pollution Control Board has in the meantime, by order dated 3/5/23/24, has taken some action against operating, my lord, into loading and downloading of flyers, my lord.
During the loading process, particles are pollution. And the company has come up with an affidavit saying that "Hey, we are doing it, but we have taken all the measures. Now, it's for the railways to also just clarify.
So the pollution control board has taken action against whom?
Against, my lord, the railway authority, my lord, allowing to operate the loading and unloading of flyers, my lord.
So they have taken some preventive
Some
measures.
action, my lord. Covering that, my lord, we have filed an affidavit today, my lord.
That is in your favor.
My lord, yes, in my favor. That should be in record.
If the railway has already taken some action against them, then your grievance regarding pollution has been redressed.
My lord, some notice has been issued, closure notice, my lord. Whether the finally it is operated or not, that should be verified, my lord. That should be looked into, my lord. Let my affidavit may come in the record, my lord.
Arjun.
I think railway should file affidavit.
Yes, my lord.
Railway
They should also file
as a
affidavit.
party.
Railway should file a
File
affidavit.
affidavit.
You are for?
I'm for the respondent number 10, Dalmia Cement.
Yes, who is appearing for the railways?
Because they are the person against whom the action has been taken.
Let us see. Yes, next week they can.
My lord, pollution control may also, my lord, is also file affidavit.
You file your affidavit, then we'll.
My lord.
Item 40.
Development.
May I please, your lordship? Lordship, as per last order dated 24 to 2024. So the lordship, the respondent authority has to file an affidavit. I have received a copy in the morning.
Lordship, in this matter, we have filed our affidavit today, Your Lordship, this morning.
Lordship may
and
kindly
if
grant
it's
us
any
3
other
weeks.
day, bring, so that the affidavit may be tagged with the record.
So Monday. The records are supposed to be put it, payment of photos. रोज पे अमेंड करके बोल रहे हैं कि पहले से सिलेक्शन होने के जो सिलेक्शन होते हैं वो भेजेंगे अब यहाँ पे एक गलती हो रही है रूल में है कि एक साल के लिए दिसंबर में नेक्स्ट ईयर में कितना हो रहा है देखते सिलेक्शन यहाँ पे इन लोग पे है कि 31/1/26 तक का जितना वैकेंसी है सब स्टॉप कर देना और
Disturbing. Particular and concept of the respondent, the counter affidavit on behalf of the respondents is filed today only. The counsel appearing for the petitioner takes some time to file counter to the reply filed on behalf of the respondent. It's up to 4 weeks.
Obliged, Lordship.
Item 41.
The government is supposed to file affidavit as per the last order of the court.
My lord, the government in earlier occasion file an affidavit to the SP of the district. But on the order dated
Chief
24.
Secretary was supposed to file.
Yes, my lord. So we have taken steps and we have got some instruction that they are seeking order 4 weeks, my lord. If your lordship,
You have to pay the compensation, sir.
yes, my lord. Only for.
You have to pay the compensation. And that has to be determined as per this motor accident cases.
Yes.
That is what the.
That is the minor law now, as per the latest judgment of the court, minor, Supreme Court. Minor.
Yes.
Person was picked up, minor, then thereafter he was killed.
Charge sheet has already been filed.
Yes, yes,
against
that is
the-
an admitted fact.
That is SP has filed, your lordship wanted, minor, the secretary home
Charge
to
sheet
file.
has been filed against
Yes,
the
yes,
hiring
yes,
officials.
yes.
What remains, what, you have to pay the compensation, sir, or interim compensation, what do you suggest? On the last occasion, we have observed, I think so.
Well, some more time, my lord, because they.
On the
Yes,
last
seeking-
occasion,
This man, he
either
was,
in this
minor,
matter or some other matter, we have already observed that why this interim compensation be not paid to the.
at that point of time, minor, he was paying a loan of about 3,60,000.
यहाँ पे सर आपका खाली वो affidavit फाइल करने के लिए
Stop this court. While the order dated 24/4/2024 has granted time to the state to file counter to the writ petition supported by the affidavit either of the chief secretary or the government to the government of Assam or the principal secretary, Home Department. Then concept appearing for the state raise 4 weeks time to file affidavit on behalf of the chief secretary or the principal secretary of Home Department. Stop. This petition is filed, paragraph. This petition is filed by the petitioner seeking compensation from the state government on account of custodial death of her husband. Full stop. It is contended that in the inquiry conducted by the state, the police officials were found guilty for custodial death of the husband of the petitioner, and charge sheet has also been filed against them in the concerned criminal court for the offences punishable under section 120B, 365, 302, 34 and 34 IPC, along with the section 98 in bracket small a /99 bracket 3 and 99 bracket 5 of the Assam Police Act 2007. Full stop. The custodial death of the husband of the appellant took place on 25/4/2020. 25/4/2020. Taking into consideration this fact, we deem it appropriate to direct the respondent state. We deem it appropriate to seek explanation from the respondent state that why the interim compensation be not granted to the appellant, to the petitioner during the pendency of this petition. Listed when?
But I'm seeking 4 weeks time, my lord. In the meantime,
Just after 4 weeks, and so you file a response that
Yes.
why interim compensation should not be granted.
yes, ma'am.
Supplementary list, item 44.
My lord, in this case, my lord, the petitioner, their MSME unit, they got an order for supply of my lord, ambulances.
Sir,
Not a single judge, my
Chaudhary,
lord,
Mr. Chaudhary, when the ambulances are there, why don't you use it? What's the problem? 7 days delay, only
Not
7
70, my lord, no, my lord, as per the instruction, I have not spoken to these people. Actually, my lord, after receipt of the LOA,
impose some penalty on him, but at least allow them. These 2 new ambulances are there. Yes, there are certain in procuring those, or if he has already booked that and those ambulance received late. Wrong it.
and let me have the instruction in that case.
Because unless otherwise ambulances are there, you will again go for some new tender and then procure that ambulances.
And they're using the old vehicles, but our old vehicles, they're using.
No, no, our,
That
their
is of
old vehicle we can
2020.
use under the terms of the contract
Yes,
itself
That is of
for a
2020.
period of 2 months.
Now 2 ambulances are there. Why don't you use it? They are parked in the hospital itself. Why don't you use?
Let me have the instruction.
Okay, day after tomorrow,
Monday.
Monday. Monday again you.
Oh, so sorry, Monday I'm not there.
They have
Let
to
it
do
be on
on
Wednesday, my lord.
Friday, Friday.
Friday, let it be on Friday.
Let me have the instruction.
Vehicles are there.
Single bench.
But my lord, on similar grounds only the law contract operates, my lord, that's it. We wish, my lord, lordship takes the view.
I got a judgment, my lord.
But here in
2023.
the ambulances cases, if you are the ambulances are there, use them. Impose a penalty on them. Whatever the penalty of for the delay. But use the ambulances, new ambulances are there. What's wrong?
And let me have the instruction.
Yes.
The only reason what apparently you are given के दो अगर ये inform कर देते, if they would have informed के सब we have already booked the vehicles, then it's okay.
So that's the requirement, my lord. Within 7 days, they have to inform the regarding.
Verbally.
And they said के we have verbally informed them, they said के okay.
And
then
after
you-
the notice, we have
use that.
informed them in writing also.
No,
They've
no,
given
they
us
have
a
not done
notice.
anything
Ask
writing. And my lord will have the instruction.
That is nothing.
Dell list for hearing item 42 and 43.
Item number 42, I appear for the petition. My lord has fixed it today for hearing.
My lord, that Monday problem is no longer there. Lordship, can this matter be on Monday? My lord? Yes.
But they are insisting whether they have written a letter saying that you take back the vehicles now. You once it,
Now,
that they should not do.
we have already asked Mr. Chaudhary,
Malam,
Mr.
that
Chaudhary
I
will give the instructions to
I
them or seek instructions from them. What's wrong in that?
My lord, in this matter, my lord, I have prepared a short note on argument along with the judgment I would like to rely on. My lord, it would shorten the time of the.
Yeah, sure, sure. Thank you. Yes, Mr. Nath? You ready?
My lord,
Yes.
in this writ petition, my lord, we have challenged the constitutional validity of the Court Fees Act on grant of probate under entry number 11 of Schedule 1 of the Court Fees Act 1870, Assam, where the rate of 7% ad valorem on a property valued more than 5 lakhs has been fixed without there being any upper limit. Now, hearing this instant writ petition, the petitioner, who was the executor, now 94 years of age, Padma Shri awardee, noted citizen of Assam, India. My lord, his brother will, he was the executor, he got the probate. He is not the beneficiary also. Now, the property was valued at 3 crores and all, and he was been directed to pay 28 lakhs on probate. My lord, here I challenge this constitutional valid because it's according to the writ petitioner, it's violative of Article 14. My lord, in other states, like in neighboring state, West Bengal, the upper limit has been fixed at 50,000. In Maharashtra, it was 75,000. In Karnataka, it's 60,000. And in Gujarat also, it's 75,000. So, my lord, all the states have an upper limit fixed.
Here, there is no upper limit.
There is no upper limit. That is the point we have challenged. Now,
Page 20 what amendment
my lord, in page number 28 of the writ petition,
Yes.
the provision has been annexed, which I have challenged. Property under valuation to the name of.
Assam Court Fees Amendment Act.
Yes.
Yes.
Entry number 11 of Schedule 1.
Is that page?
It starts from page 28
Yes.
and the
29, last paragraph.
29, last paragraph. Yes.
Such amount of value exceeds 2 lakhs and 50,000 rupees on the portion of the such amount shall be valued which is excess 2 lakhs 50,000 rupees or 3 lakhs. That's 5.5%. And it's go on increasingly.
When such amount or value exceeds 3 lakhs of rupees, on the portion of such amount, value is in excess of 3 lakhs rupees up to 4 lakh rupees, 6% per annum.
Yes, then it
And
then 6.5. Then
such value is so and so 6.5.
then the last one
5 lakhs.
5 lakhs.
On the portion amount which is in excess of 5 lakh rupees.
It's next page 7%.
7%.
Yes.
Yes.
There is no upper limit fixed. In our my submission is there is a difference, basic difference between uh, transfer inter vivos or donatio mortis causa. From a living person to a living person, a transfer is now the stamp duty is payable. Here, the executor might not be a beneficiary also. The beneficiary might be the other persons. Then if the upper limit is not fixed, then after a period of certain years, when I have to pay a amount of rupees 28 lakhs for executing the intention of the testator, that is unconstitutional. My lord, kindly consider a proposition.
Yes.
A property, a commercial property in Noriman Point, someone has gifted to his heirs. My lord, he has to pay only 75,000, but the property is Noriman Point is valued at several crores.
Yes.
Now in Assam, for these reasons, government is losing revenue. They said, my learned friend argued on earlier occasion that revenue matter court should not interfere. My lord, government is losing revenue in Assam. My lord, and if I file if I ask my learned friend's client, the state government, then how many probate case has been filed in Assam? Considering the other states, it's negligible. Government is losing revenue because of the stringent provisions. No one is interested in filing probate.
Yes.
My lord, I will rely on two judgments. My lord, first I like to rely on the judgment of Government of Madras versus Zenith Land. And that's reported in 1973, Volume 1, Supreme Court Cases, page 162. My lord, it's a 5 judges bench judgment.
Yes.
My lord, I have annexed with my written notes. It's in page. Just page 74.
74.
Yes. My lord, here, my lord, Supreme Court had the occasion to deal with the provisions of Court Fees Act and decides that the court fees does not mean any tax determination of fees in a particular case, and fees taken in court are category by themselves. Correlation.
Which para you are referring?
My lord. No, para क्या बोलो?
32.
Para 48. My lord. पेज का बोलता है.
Yes.
86.
Yes. Page 86, my lord, of the judgment, my lord, of my written note.
Yes,
Paragraph 48.
yes.
We agree with the Madras High Court in the present case that the fees taken in courts are not a category by themselves and must contain the essential element of the fees as laid down by this court. We also agree with the following observations. Then the observations from the Madras High Court have been set out. If the element of revenue for the general purpose of the state predominates, then the taxing element takes hold of the levy and it ceases to have any relation to the cost of administration of law to which it relates. It becomes a tax. Here, in an uncontested probate matter, when court is less burden, not like a suit. Even in suit, there is a upper limit. In an uncontested probate matter, court is less burden. So there has to be a correlation between imposition of the court fees determined, and it cannot be like that it looks like a imposition of tax. Hmm? Where? Okay. In a suit, my lord, in Assam, the maximum court fees is 11,000. My lord, next judgment is, my lord, where the Bombay, Maharashtra has fixed the upper limit. Previously, it was also not fixed, and it was 5% on a property valued more than 5 lakhs.
Yes.
This is 1989 1 supplementary 1 SCC. No, it's not that. The Ashtatana and Sekti. What the content? PM Ashtatana.
Shamlal Batra, which
No,
case?
my lord, I'm
89.
89.
Okay, 89, yes. That is of
Yes.
PM
Astam.
Savarna, Shetty and others.
Yes.
Yes.
Page 88.
Yes.
Lordships, kindly come to para 90 onwards. 90 to 95 is the relevant portion.
95.
One note and one note. In the appeal of the state of Maharashtra, arising out of the Bombay Court Fees Act 1959, the High Court has struck down the impugned provisions on the ground that the levy of court fees on the proceeding of grant of probate and letters of administration ad valorem without the upper limit prescribed for all other litigants, the court fees in the present case amounts to 6,14,814 is discriminatory. Pat on the point, my lord. The High Court has also held that there is no intelligible or rational differentia between the two classes of litigation, and that having regard to the fact that what is recovered is a fee, the purported classification has no rational nexus to the object. The argument was noticed by the learned single judge thus. Petitioners next contended that the impugned clause discriminates as between different types of suitors and that there is no justification for this discrimination. Plaintiffs who go to civil courts claiming decree are not required to pay court fees in excess of 15,000. Here it is 11,000. This is irrespective of the amounts claimed over and above rupees 15 lakhs. As again, these persons claiming probate have no such relief in the form of an upper limit to fee payable. This contention was accepted by the learned single judge, who has upheld the appeal. Indeed, where a proceeding for grant of probate and letters of administrations become a contentious matter, it is registered as a suit as proceeded with accordingly. If in respect of all other suits of whichever nature and complexity of upper limit of rupees 15,000 on the court fees is fixed, there is no logical justification for singling out this proceeding for an ad valorem input imposed without being benefit of some upper limit prescribed by the same statute respecting all other litigants. Neither before the High Court nor before us here was the imposed sought to be supported or justified as something other than a mere fee, levy of which is otherwise within the state's power, or separate fee from another distinct source. It is purported to be collected and sought to be justified only as court fees and nothing else. The discriminations brought about by the statute, in our opinion, fails to pass the constitutional matter as rightly pointed out by High Court. High Court, in our opinion, rightly held there is no answer to this contention except that the legislature has not thought it fit to grant relief to the seekers of probate, whereas plaintiff in civil suits were thought deserving of such an upper limit. The discrimination is a piece of class legislation prohibited by the guarantee of equal protection of laws embodied in Article 14 of the Constitution. On this ground also, item 10 cannot be sustained. We approve the contention of the High Court, and decisions of the High Court is sustained on this ground alone. In view of this, any other ground urged against the constitutionality of the levy is unnecessary to be examined. My Lord, Supreme Court has, on the basis of this judgment, in the last paragraph, Supreme Court has sent the matter to be considered by the state legislation. Thereafter, the Maharashtra has fixed the upper limit at 75,000. I have annexed that statute also, along with my note.
Yes.
Several opportunities have been given since 2018 to state to come up with a proposal for fixing up upper limit by Lordship's predecessors office.
If they are not willing to, then
My Lord,
they are not willing.
my Lord decides on merit. My Lord, this is my submissions.
Yes.
But in fact, but the last submission has been made on behalf of the petitioner. There is a process started by the state government. In fact, my instruction is with me. Kindly have a look.
You should have, before we start hearing, you should have informed us. Okay, we are already contemplating to give relief.
My Lord, it was informed much before also,
It was
but
informed.
nothing has happened.
Yes,
Your Lordship, this has been happening now for the last successive hearings.
Yes.
Your Lordship, I'm appearing in item 43. This is a connected matter. Whenever Your Lordship has 2 minutes time, I would like to make 2 submissions, Your Lordships.
Look, my instruction says that in inviting reference to the subject cited, I am directed to inform you that a process for considering the matter of levy of ad valorem court fee for grant of probate under entry 11 of Schedule 1 of Court Fee Act 1870, Assam was initiated by the Government of Assam on 23/8/2023. It may be mentioned that apart from the matter of ad valorem court fee for grant of probate under entry 11 of Schedule 1 of Court Fee Act 1870, Assam, as per direction of Ministry of Law and Justice, the matter of overhauling the entire fee structure of Court Fee Act 1870 is also under consideration by the revenue department, government. And my latest information is that because of the election and all these things, they could not hold the meeting.
Some time, it will take a long time. Yeah,
Well,
still they are
what?
proposing is whether to this code fees act is to be amended or not. They'll ask all the state governments and then they'll respond and it will take years. It's not a matter of this.
In our the stand of the government in this matter, we have already filed the affidavit, that I will take your lordship, and as so far the process initiated by the authorities, my respectful submission to the lordship may give a time frame. Let them come do it, otherwise they are doing it.
Court judgment is very clear on that.
But Supreme Court judgment, yes, Supreme Court judgment has finally remanded the matter to the authority.
That what we will do. We are not going to.
Yes, yes.
Here also we want that.
That we will do.
Yes, yes.
Yes, Mr. Chaudhary.
In fact, I am also relying on this same judgment.
For what? You are relying on for what? The wherein the Supreme Court has said that this can't be done. This is discriminatory.
No, it is the Supreme Court, in my respectful submission, has said that the state legislature has to consider, and ultimately it is left to the wisdom of the state legislature.
Obviously. But the court has in so many words, the Honorable Supreme Court has expressed that these not fixing any upper limit is discriminatory. And that is for the purpose of filing suits, there is an upper limit, and for the probate, there is no upper limit. What else they have argued here?
No, in fact, the Honorable Apex Court has said that Article 14 doesn't come in this matter.
It is there, sir.
No, my lord.
I could.
In the
this page number 119. The High Court in an opinion rightly held there is no answer to this contention except that the legislature thought it fit to grant relief to seekers, whereas plaintiff in civil suits and through deserving upper limit, the discrimination is a piece of class legislation prohibited by the guarantee of equal protection laws embodied in Article 14 of the Constitution of India. On this ground, although item 10 cannot be sustained.
Yes.
This is what the Supreme Court has held, that the learned single judge has rightly held this.
Kindly note para 31 of that judgment. There are the issues are noted down.
31.
Para 30. Lordship is holding 1989.
On the contention served by the hearing of the party, point of determination. Yeah.
Issue number 3, Issue number 3. C,
Yes.
Whether at all events the distribution of the burden of fees amongst those on whom the burden falls as ad valorem principle dependent merely on the amount or value of the claim in the case, irrespective of the nature, quality and extent of adjudicative services, is arbitrary and violative of Article 14 of the Constitution. Lord, kindly come to 42, Lord.
That is altogether different, sir.
Finally. And 79, Lord. 42 and 79, Lord.
Yes. Yeah.
Lordship.
42 and
42 and 79, Lord.
Read 42.
Sorry. Lord, I'm reading also 39, Lord. The para 39 in Srinivasa so and so versus so and so in this.
Yeah.
The
Where you are reading 39? Yes.
Lordship. Well, actually, just I'm holding the other copy, Lord. I'm just reading. The correlationship between the levy and the services rendered the expected is one of general character and not of mathematical extensive. All that is necessary is that there should be a reasonable relationship between the levy of the fee and the services rendered. Then kindly come to Lord, to para 42, Lord. In Keval Kishan Puri versus State of Punjab, this court in para 435 of para 23.6 and 7, the element of quid pro quo may not be possible or even necessary to be established with arithmetical exactitude, but even broadly and reasonably, it must be established by the authorities who charge the fees that the amount is being spent for rendering services to those on whom falls the burden of the fee. At last, a good and substantial portion of the amount collected on amount of fee may be in the neighborhood of 2/3 or 3/4 must be shown with reasonable certainty as being spent for rendering services of the kind mentioned above. But I'm indicating this.
This is what the Supreme Court has quoted a judgment, and what is your argument?
I am indicating that the argument which is advanced by the petitioner that the fee has to be charged considering the services provided to them. On that, my lord, I'm submitting that this judgment has clarified that that is not the sole criteria because the entire thing
Ultimately, what is held in the judgment, we have to go through that, whatever the discussions and arguments are concerned, how
Lord,
they are
after discussing
relevant for that
after
purpose.
discussing para 79, kindly see, my lord, para 79.
Yes,
Lordship. The problem is indeed a complex one, not free from its own peculiar difficulties. Though other legislative measures dealing with economic regulations are not outside Article 14, it is well recognized that the state enjoys the widest latitude where measures of economic regulations are concerned. These measures for fiscal and economic regulations involve an evaluation of diverse and quite often conflicting economic criteria and adjustment and balancing of various conflicting social and economic values and interests. It is for the state to decide what economic and social policy it should pursue and what discriminations advance to those.
These are the discussions, certainly, but after discussing that, what ultimately the Supreme Court has held.
It is relegated to the
Article 141 judgment. It is a law of the land, what they have held.
But it is ultimately it is relegated to the.
So then why you are referring to all those discussions and arguments? Just tell me where is the point in it?
But my submission is that since the stand of the affidavit is not, kindly have a look at the affidavit also.
Sir, what do you want to say whether this judgment of the Honorable Supreme Court is applicable or not? Absolutely. Then what is the point in arguing further?
My submission is that the the revenue of the state is a concern for the department. But in the affidavit we have stated the Honorable Apex Court decision is also there. Now the matter is under consideration of the authority.
That is not the consideration, sir. That is you are simply this proposal is for repealing the Court Act or amending suitably, but it will take years together, sir. It is simply
Specifically, they have said about entry 11 of Schedule 1 of the Court Fee Act relating to probation.
No.
And
the law ministry letter we have already gone through. That has also been circulated to us, and in which they said, what are the views to do this, do away with all this and that. This is what the letter is. We have already gone through. Yes, Mr. Chaudhary.
Thank you, Lordship. Your Lordships, in my case, I happen to be the beneficiary of a property under a will, and similar to the first case in which my learned senior argued.
Ultimately, the provision which is in the challenge in the first case, that is also under challenge, na?
Correct, Your Lordships. My petition is identical to the petition in item 42.
Maybe you are the beneficiary, and here in this case, he was not the beneficiary, but the point in law is involved in
Absolutely, Your Lordships. I am also challenging the vires of this particular provision. I just have to add one point, Your Lordships, in addition to whatever arguments the learned senior has argued. And this is also in response to what my learned colleague from the other side just spoke about, that there is a fundamental difference, Your Lordships, between a fee and a tax. And it is settled law that a fee cannot assume the character of a tax. Yes. In this case, one has to also see the objective of the Court Fees Act, which is correct. The learned, my colleague on the other side is correct to point out that while revenue collection may be an important goal, what also has to be seen is a corresponding relationship between the fee that is charged and the service provided. Your Lordships, compared to civil suits, compared to any other proceedings, probate proceedings are by and large uncontested. And in that scenario, it would be my submission that there is absolutely no correlation between the service that is rendered and the fee charged. And that is why I submit that what is happening currently under the impugned provision is that I am being effectively charged a tax, and that could not have been the intention of the legislature, of the statute, your lordships. Apart from this argument, your lordships, everything else is already in my petition. I have nothing more to submit. I wholeheartedly mirror the submissions which have been advanced by my learned senior in item 42, your lordships.
Any law points?
Your lordships, I'm also relying on the exact judgments which have been already quoted before you, so I will not waste your lordship's time. The Supreme Court judgment wherein the Bombay High Court provision was struck down as unconstitutional, to be particular. If your lordships has my petition, I would just like to point out two paragraphs from my writ petition, your lordships.
Yes.
If your lordships has my petition, I would just like your lordships to note paras 13 and 14 at pages 12 and 13, just in response to whatever has been presented by my colleague from the other side so far.
13 and 14.
Correct, your lordships. Paras 13 at page 12, where I talk about how there is a difference between fee and tax and how what is happening in the current situation amounts to compulsory taxation. Here, I also deal with the objectives of the Court Fees Act and how a balance has to be struck between the goal of revenue collection and the end goal of making sure that somebody who has just obtained a property under a probate, under a will, is not harassed by having to pay an exorbitant amount of court fees just to obtain the fruits of that will.
Para 13 and 14 you are referring to now?
Yes, your lordships. Paras 13 and 14 at pages 12 and 13. This may be useful to your lordships while deliberating upon the issues presented before you.
Fine. Which one?
My lord, only one aspect, my lord, I just want to point out. My lord, if today someone wants to buy a property, commercial property in GS Road, he has to pay a stamp duty of 7%, 1.1 registration fee. That's comes around 8%. Now he wants to buy a property. Man, I inherit one property. Man, there is when my father bought that property, he has paid that stamp duty to the state. Man, it's double taxation. I inherit. My ancestral property I inherit by way of probate.
Then your argument is either no such fee should be charged or there must be some upper.
There must be some upper limit.
That's two different things.
Will is not.
My lord, my client says is 94 years. My lord, lordship kindly consider, my lord, pass the, my lord, reserve for judgment and pass the judgment.
That we will do, but if that 94 years, that is not for her fault, sir. When the petition is pending since 2018.
My lord, I have been trying, my lord, I'm coming from outstation regularly.
Yeah.
Will has nothing to do with inheritance, my lord. And secondly, one of my affidavit paragraph 2, 3, and 4, that may be kindly considered.
That's it.
Got it.
Order reserved.
Much.
Oblige, your lordships. Thank you so much, your lordships.
Timing and asking.
Yes.
My name.
Yes.
Me.
Yeah.
Please from the
Thank you.